Great, so we'll just wait a moment for everybody to finish joining. Welcome everyone. Okay. Those just joining, we'll start in just a moment. Perfect. Okay, so just as a brief introduction and some housekeeping first. For those who don't know me, I'm Laura Kaster. I'm the Executive Director of the International Mediation Institute. And before I introduce our fabulous guests today, just a bit of housekeeping. So for those who haven't used Zoom webinar before, you'll notice that there's a Q&A function at the bottom of your screen or on the bottom of your phone. If you do have questions during the presentation or in the Q&A, which we'll have after the presentation, please do insert them there and we'll make sure to get through all of those. Okay, the chat is also enabled, but please post questions in the Q&A. With no further ado, I'm really delighted that we're having this webinar today, where we'll be talking about the fantastic New Jersey Statute and what it means for enforcement of mediated settlements now, even prior to the enforcement of the Singapore Convention in a few months. And we have 4 luminary mediators with us today. They're all IMI certified, of course. We have Laura Kaster, who is the former head of litigation at AT&T, as well as the chair of the only ADR in court. We've got Professor David Weiss, who probably several of you are quite familiar with, who runs IDR, which has a long-standing partnership with IMI. We have Jennifer Brandt, who, as well as being a mediator, she's on the board of directors, as well as mediation ambassador for the Foundation of Sustainable Rule of Law Initiatives, which is quite a long title, but we'll roll with it. And then Bob, who I think we can call Mr. Mediation New Jersey, is also the creator of Court Annex ADR programs in the States. So welcome everybody. And with no further ado, I'd like to invite you to start with the presentation.
Thank you, Laura. So first of all, I also like to acknowledge that the IDR is part of New Jersey City University in our state. And we're going to begin with business. This is what the focus of our discussion is today, and how we're helping international business around the world. Starting some time ago, there was an insurgence around the world to find ways that we can help businesses navigate the waters in a globalized environment. And part of that was to figure out a pathway to support both foreign direct investment, commercial businesses, and find ways to help not just international large-scale businesses, but small and medium-sized businesses as well. This began with an initiative that was part of a group of leaders, both in the business community, the legal community, governments, all around the world. And it became known as the Global Pound Conference Series, which was put together by IMI. In fact, NJCU IDR was a big sponsor of one of their programs in New York City. And this took place throughout cities around the world. And part of this discussion, which was attended by thousands and thousands of participants, both in live sessions in cities, as well as online, was the collection of important data. What was that data? The data was to really get the pulse of companies, not just those that support alternative dispute resolution or mediation, but those that are really frontline CEOs and COOs and those that are really doing business. And one of the things we wanted to find out was specifically, how can we find ways to increase their productivity and support them when conflicts arise in order to give them specifically predictability and certainty, especially in the international arena, where they're not just doing business, but they also are in foreign jurisdictions that they may not be necessarily comfortable with. And this began a narrative and a discussion that included what is in front of you, which were surveys that were included in this entire discussion, which took place over several years and culminated in very important data. And that data, as you'll see on the screen, included that about 44% of those that we surveyed through the IMI process wanted to see some sort of mediation framework for enforcement. So when we look at why that is, it's because mediation settlement agreements are contracts. And contracts don't necessarily standing alone have an international enforcement mechanism. So out of that came two important processes, which my fellow colleagues will also be discussing in more detail as we move forward today. One was, of course, which some of you or many of you are familiar with, is now the new Singapore Convention on Mediation. And that was a consensus building process, which really began years even earlier in the 2000s, of how to find a way to create a similar concept between what the New York Convention does for arbitration awards. The second was a statutory framework, which my colleagues will get more into detail on, which is another model that is being used and has been implemented by law in the state of New Jersey. And this is a different alternative or option that can also be accessed. At the end of the day, the importance of all of this is to find ways that we can increase commercial activity. Given the pandemic and given the environment we're in today, this is probably even more of an important discussion than ever before, because we're going to find a lot of conflicts, unfortunately, and a lot of issues that are going to have to be unwind around the world in order for business to get back on its feet. And I think today's conversation will be part of that story of how we can help international businesses, small and large alike, fulfill those obligations. So I'd like to start off with that in mind, and I'd like to pass it now on to my colleague, Laura Kaster, who is going to give apologize. I think in our order, it will be Jennifer Brandt, who will now give a little bit more detail on this, on our discussion today. Thank you.
Great. Thank you, David. Thank you, Laura, both Lauras actually, and Bob. It's a pleasure to be here today. I'm going to talk a little bit about the Singapore Convention because it really, the Global Pound Conference set the stage for the creation of the Singapore Convention. It was a wonderful feat. So many countries were involved, so many different legal systems, jurisdictions, and it was actually signed last August. And at that time, there were 46 signatories, including the important economic powers of the United States, China, India, South Korea. Since then, it has been ratified by 3 countries, and it will go into effect in September of this year. Now, the reason for this was to try to put, in a sense, mediated settlements to be binding and enforceable throughout the world. And obviously it starts with those countries that who have ratified it. So for example, the New York Convention, which has been around for 60 years, has now approximately 163 signatories. And that really is the basis for which arbitration awards, arbitral awards, will then be enforceable in all of those 163 countries. And the purpose is, mediation is a wonderful platform. It's a wonderful benefit. There are certain different aspects that I believe are improvements over arbitration. And one of them, especially within the business community, is the preservation of relationships. Preservation of business relationships, family businesses, which are a very large proportion of businesses worldwide. It's faster, it's cheaper. There's certainty, as David had mentioned also. And so there is a need, and there is an increase in the amount of international trade that is happening. So mediated settlements it will become as important as an arbitral award eventually. But there's one problem. The Singapore Convention, as wonderful as it is, it will take time. As I said, only 3 countries have ratified it, which means that a mediated settlement will only be binding in those 3 countries. Those 3 countries are Singapore, Fiji, and Qatar. None of the other major countries have ratified it. The European Union is very much against it. In fact, I don't believe any European country, nor the UK, has even signed it, and they're very much against it. So I think that's problematic. Sometimes it takes litigation. It takes years of litigation to make sure that it will become binding. And the point of the convention is to prevent litigation. It's to prevent the fact that if you have a mediated settlement and you don't have a convention like this, or you don't have a law like we have in New Jersey, you then have to relitigate it to enforce that contract. There's no certainty. You'll be in different jurisdictions. And in many countries, we know it takes years, sometimes decades for it to happen. So that can be a very big problem. So we believe that although Singapore Convention will eventually be ratified by more countries, it is a wonderful process, although it's imperfect, as all conventions are. We believe that the system we have in New Jersey is really an excellent one. And one quick aside, if I have the time, it was my understanding that the Singapore International Arbitration Center actually wanted a model very similar to what we had in New Jersey. Thank you. Bob.
Good morning. Pleasure to be here. New Jersey, with the inspiration of Professor Weiss and the hard work of Laura, myself, and Jennifer, went down a path and got New Jersey to adopt legislation entitled the International Arbitration, Mediation, and Conciliation Act. We think this was breakthrough legislation, and what it provides, essentially, is an opportunity to resolve cross-border disputes utilizing a mechanism adopted by the New Jersey legislature that allows, in a mixed modal process, convening an arbitration, converting it immediately to a mediation, and if the mediation is resolved with a writing, the mediator then converts back to being the arbitrator and enters a consent arbitral award. Why is that important? That's important, as Jennifer suggested, because 163 countries around the world will recognize and enforce an arbitral award. And so it allows a mediated settlement, which we think is the better mousetrap in order to resolve a dispute, to be binding. Now, in order for the act to apply, it has to be be a resident and non-resident of the United States, so it's cross-border. If there are two or more persons that are residents of the United States, if the dispute involves property outside of the United States or relates to a contract that envisages enforcement or performance outside the United States, or bears some other relation to a foreign country. And it does not apply to local ownership of land. It doesn't apply to family disputes. So what have we done to implement this? We have formed the GMXC, the Global Mediation Exchange Center, which is right here in New Jersey, that will allow, and this I think is really important, this is not about law, this is about business. And this allows small and medium-sized businesses to do worldwide business and have the comfort of being able to enforce the settlement. So if you want to take a look at this, you want to ask about it, you will have disputes you want to refer, we have IMI certified mediators available to solve your cross-border disputes. Laura?
Thank you, Bob. And thank everyone for joining us this morning. You know, the world is in a really difficult place. We're all suffering together, but that also demonstrates that we're really all connected. I mean, there could be nothing more vivid to demonstrate that the world truly is flat, that we are all connected, and that we all need solutions to bring business back to its former self, all around the world and with each other. And so what we've been talking about is a way to solve disputes by video conferencing online safely right now. So the reason that we established this process, this ARB process that Bob described, is because of a provision in the New York Convention, which requires that the dispute exist at the time that the dispute is dealt with in arbitration. So therefore, you have to start a dispute. You have to bring a dispute, an existing dispute that is filed in a court or another arbitral body, or a dispute where the parties agree to submit it to arbitration, And then it will be, under our process of the GMXC, immediately converted. The arbitrator will change hats, become a mediator, and immediately work with you to resolve the dispute. If the dispute is resolved in a settlement agreement that the parties agree to and sign, then the mediator arbitrator will convert back to an arbitrator and enter a consent award on that settlement agreement. So, and does a consent award work under the New York Convention? It does. There's case law in the United States that establishes clearly that a consent award is an arbitral award, and therefore it will fit within the New York Convention. And the reason is a public policy one. They want to be able to settle arbitrations as well as anything else. Now, I think we all mentioned that there was a craving internationally by business for a mediated solution, a hybrid solution. Businesses don't really care how their problem gets resolved. They don't focus on the process, but they're demanding a quicker, more expeditious, less costly process, and they think that should include mediation. And internationally, mediation has not been as popular as it is in the United States, primarily because of this enforcement problem. So we have the solution in New Jersey. What do you need to do today? You need to have clear buy-in by both parties to subscribe to this process, to submit the dispute by a submission agreement or by an agreement to move it from the litigation process or arbitration process to our process. You have to have an agreement that if a mediation results in settlement, that you will allow it to be, the settlement agreement to be converted to a consent award. And we have all of these on the rules of the GMXC, and we're ready to serve your problem now. We also have flat fees. And so it's a really valuable alternative to what is now available to businesses that need to proceed forward and get things resolved even while many courts around the world are closed. So the ArbMed process is here for you. We can do it now, and we look forward to working with you. And we're excited about the prospect of working with IMI to do so. I want to make one comment about Professor Weiss. He really was the visionary behind this idea and this process. And his IDR Center is also working on this for other types of disputes in what he calls a transdisciplinary approach to business problems generally and resolving disputes. And it's really an admirable and amazing thing that he got this through without dissent really in the New Jersey legislature, because it is business focused. And we at GMXC, all of us, really appreciate your joining us today, and we look forward to answering your questions. And I'll take the initial questions on the Q&A and read them to my colleagues. And Laura Skillen, if there's anything else you want to tell us about that process, then thank you very much for doing that. Should I open my Q&A?
Sure. So there's one there, and I've jotted down a few other people have sent to me. But I do encourage anyone, if you've got a question, please log it by the Q&A section and we'll get straight to it.
Okay, the first question is for Jennifer. How will ratification of the Singapore Convention help any country and its various sectors in resolving disputes?
Excuse me. Okay, thank you for the question. Ratification will begin the process of making more and more countries part of it, which means that you can then enforce it automatically in those countries that have ratified it. It is a buy-in to the mediation process. It sets the stage for mediation really becoming on a par with arbitration or an alternative to arbitration in the right setting. So the more countries that ratify simplify it, the more enforceable it is in more places. So hopefully places like the United States, China, India, major economic powerhouses, they can then enforce these mediated settlements at this time and as soon as ratification. But ratification is a slow process. As I said, it took 60 years to have so many countries sign on for the New York Convention. Hopefully it won't take as long now, and more countries will sign and see the need for resolution quickly, video conference wise, because personally we can't do it. And even if we didn't have the pandemic, the fact that it's international, doing it in the virtual realm certainly facilitates resolving it quickly and economically. Thank you.
So
Laura, could I comment? One thing that you might want to take a look at, you see up on your screen the GMXCmediation.com website. Our rules are posted there. They're pretty straightforward. And we also have the submission agreement forms available. We hope you'll talk to your friends and neighbors and let them know that this vehicle is available because we think it's the ability to enforce these settlements is really what's going to make mediation available around the world, and hopefully as popular as it is in the United States.
So, and I just want to reinforce what Jennifer and Bob just said before I go on to the next question, which is that the Singapore Convention is a brilliant solution. It has some issues, but it's not really there for us yet. It won't be there for us to use until a lot of countries sign on, and then it will be usable only in those that do sign on to enforce a settlement as a judgment. So in the meanwhile, and it may be many years, really the only solution that has the enforcement of a mediated settlement is our solution. So that's what I wanted to tell you all. So would ratifying a convention, the Singapore Convention, make a difference if the country already has a law that makes mediated settlement, both local and international, directly enforceable? David, do you want to take that one? David, you're on mute.
I apologize there. I was keeping on mute for the panel discussion. The issue is that even if the country itself has a mechanism that is specifically tailored only to mediation, then even if it has language in the legislation that projects out to the world, the enforcing nation state that you are seeking your judgment in will not necessarily recognize it. The uniqueness about both the Singapore Convention on Mediation and more specifically the New Jersey statutory framework is that it is one that Singapore at some point in the future will be recognized by nation states all over the world. It's very similar to what happened with the New York Convention, which began its process in the 1950s and worked its way through the system for about 20 or 30 years. In fact, the United States didn't even sign on until 1973. And then it took case law following that in order for it to be recognized in the United States. As far as the New Jersey statute, which I think is what is really unique, is that we are not projecting a statutory framework out to the world under the guise of a mediation and enforcement mechanism, but rather under an arbitrable award pursuant to the New York Convention, which is already recognized by other countries around the world, about 157 nation states. Laura?
Thank you so much, David. So I have another question, and I'm not sure I understand it. Is the MEAD-R process used to solve disputes in consent award? The process that we've set forth requires the filing of an arbitration followed by immediate mediation by the same neutral, and then the conversion of that, if a settlement is reached, of that settlement to a consent award. So yes, our MEAD-R process is critical to our result, and it is, we believe, endorsed under the New York Convention.
Laura, could I comment with I think the one thing that we did not mention, let's assume you commence the arbitration, converts to a mediation, and you don't end up with a enforceable settlement. What happens next is you then continue to arbitration. So whether you started in litigation originally or started in arbitration originally, you then go forward in whatever your agreement says to an arbitration to resolve the dispute. So that's sort of the outlet under those circumstances. And with respect to MedArb, MedArb usually means you do a mediation, and if you have a couple things left over, you send those to arbitration. This is a little different because in our MedArb, you come to a resolution and you immediately have that person, as Laura said, change hats and convert the award.
Well, I would say, Bob, one slight friendly amendment to your answer is that you could resolve part of the dispute.
Yes.
And enter a consent award on part of the dispute and send the rest of the dispute to arbitration. So there is that kind of possibility.
Yeah.
And we have another question, and this is directed to Bob Margulies. You mentioned that the family disputes are not covered. Would that mean that a family dispute involving an otherwise covered dispute is not covered in the new law? So I think that's addressing family business disputes.
Yes. I believe that the concept in the law that relates to family or domestic relations is talking about divorce and not talking about family business disputes.
That's correct.
The other thing you could do in if you had essentially a divorce dispute over the economics, which is usually what these are really all about, I don't see any reason that by merely not labeling it as a domestic relations, but talking about it in a business sense, you could probably utilize the process as well.
Thank you, Bob. So
Also,
Jennifer.
under the Singapore Convention as well, family matters are excluded. It has to be a commercial case. So family matters, employment cases, inheritance cases are all exempt under it. So if it's a family business, clearly it would be covered, but any domestic in the context of a divorce would not be.
Thank you, Jennifer. And this is another question for you. What is the reason for your opinion that, in your opinion, that European countries are not supporting the Singapore Convention?
Okay, it's an interesting question. Many of them feel that they don't need it, that they believe once you mediate and people agree, there's the buy-in. So generally, statistics show that mediated settlements generally don't need as much enforcement because there's a buy-in and people have fashioned their own resolution. But there are two sections of the Singapore Convention, particularly specifically, that people have complained about. And one of them has to do with, there's a requirement that you need to prove a mediation took place. And one of them would include a mediator's signature on a settlement agreement. Now, very few mediators that I know in any country would agree to sign a settlement agreement. Also, that the mediator somehow has to be part of it by indicating that the mediation was carried out, or the attestation by the institution where it was done has to have a signature. And then, of course, there's this catch-all phrase, in the absence of one of the above, any other evidence acceptable to the competent authority. So partially, I believe mediators are hesitant to really be involved by signing on or proving or being called as a witness in any manner. That's one aspect. And another aspect, that was Article 4 of the Singapore Convention. And the other aspect under Article 5 has to do about any failure and possible wrongdoings or shortcomings of what the mediator did. So for example, one of the articles says if there's a breach by the mediator of standards applicable to the mediator or the mediation, without which that party would not have entered into a settlement agreement. That's one. Then there was another part of it. If there was a failure by the mediator to disclose the circumstances that may raise justifiable doubts about the mediator's impartiality or independence. So I believe to some extent, mediators are afraid that the burden will be put on them to get involved in the process, to be sued, to be called as a witness, and to be challenged by these provisions.
Laura, may I amplify that too?
Yeah,
Laura, please. No, you first, and I'll amplify some of this.
Okay, so having attended some with David, David was very involved in the hearings at the UNCITRAL Group 2. The concerns of the European countries have to do partly with their own set of encouragements for mediation or not mediation. And also there was a concern about money laundering and other issues that really are sort of outside political questions about mediation in general, and mediation, favoring mediation or not favoring mediation, and wanting to control the rules themselves within their communities, especially the European Union. So I'll pass that to David, but I don't think that the concerns of the mediators per se were, and I think there are many, were particularly influential on the voters in the process. David?
Thank you, Laura. Yeah, there were a number of deliberations between our working group 2 sessions in Vienna and New York on this very important issue. And that is why, for those that want to dive deep, you'll notice there was a compromise that came out of this during a very cold winter day in New York City when even the UN was closed. And it was the compromise for the EU was in model law plus the convention. Now, why was this? There are 2 real elements to this that should be discussed and will be continued to be discussed, I think, for some time. The first one is more of a general comment that Laura was alluding to, and that is the development of mediation. It continues to increase throughout the world, but in a lot of countries within the EU, they're still getting used to what mediation really means within their cultures and how they use mediation and get comfortable with mediation. And part of that is culture, and part of that is their legal structures as well, where litigation is relatively cheap compared to places like the United States. The second one is really more of a scholarly and jurist discussion. And there are some concerns of whether or not the Singapore Convention has created a special contract. If you remember my first comment when I opened up this morning, mediation settlement agreements standing alone are contracts. So the Singapore Convention has now created, in some people's opinions, a special elevated contract pursuant to the convention. And some nation states are going to be concerned regarding vis-a-vis their national sovereignty of whether or not they have now, by adopting and ratifying the Singapore Convention, have given up some liberty to how their courts and their societies from a legal system level have approached this issue. And I think that's going to be an ongoing discussion for some time and will ultimately, I believe, optimistically be worked out as any reservations or concerns were created during the New York Convention. And I think that's really also highlighting why the New Jersey Statute has not elevated mediation contracts to a special level. It has converted the settlement agreement, as has been discussed today, to an arbitrable award during an arbitration process pursuant to the New York Convention. So we're still staying within the 4 corners of what has already been well developed out, well accepted around the world framework. Thank you, Laura.
Thank you. And I just want to interrupt a minute because we have a very special attendee among us, and that's Debbie Masucci, who was really critical to the IMI participation in all of the work on the Singapore Convention. And she has some interesting insights into this problem. She believes that it is really a political problem having to do with the EU versus its own members and what they really want, whether they want to sign on as a group or as individual countries. And in addition, they want to assure that it doesn't compete with any EU regulations. And some of their participant countries say that it's not necessary because they are working on a new regulation and a set of different arbitration and mediation processes. So we have Debbie, and I know that she's also put some comments in your chat screen, so you can look at those as well. And I hope we've answered that question. I have another question on the general business ethic or lack thereof in supporting mediation and the effort of some entities within societies to block any bills making mediation more effective. How can we promote mediation in general? I'm going to pass that on, but I also think that this whole discussion does promote mediation, and part of it is this enforceability issue. But Bob, do you want to comment on this?
Well, since I think this is the the Better Mousetrap, a lot of what I've learned in New Jersey is what had to happen in order for both the legal community and the business community to buy into mediation. They had to touch it, they had to try it, they had to feel it, they had to have success with it, and they had to see what the economic efficiencies were with it, and the advantages of being able to come to a result that wasn't imposed upon them, but was consensual, and it was a culture change. So a lot of this is really all about a culture change. So when we designed our program, we forced people by an order of the court to participate. And now what happens is if you're in a lawsuit and you want to have a settlement conference, the lawyers say, we have to go mediate. Well, I'm a mediator, so that's fine. People don't even know how to negotiate with each other anymore without a mediator. And that's sort of how the culture has changed. We have to figure out how to do that. I know we have the, in Europe, the governments have tried to impose mediation in a way, and it has not, it is, as far as I know, has not been that successful. But this is a matter of education and letting people try it.
Yeah, and I think I do think a large part of the hostility is because it would require relitigation if people don't enforce it. I think in general, mediated solutions are more well received and less frequently litigated post-mediation, but still the prospect of starting over is too onerous.
But Laura, there's one other thing. Lawyers have been a problem too, because this is something new for them, and it changes their business model on how they're going to function, and that's been a bit of an impediment, except for those that are we call enlightened and understand that in many instances this works for their clients.
If I may jump into this, Jennifer, please.
Okay, thank you, David. I want to add that with my work with the foundation, we travel to a lot of different jurisdictions, from India to Brazil to Bulgaria, Croatia, Republic of Georgia, all over the world, where we work with the countries, we work with the court systems, we work with the judges, we work with the attorneys in promoting mediation. And it is really, it's a mindset. We talk about hostility. I mean, New Jersey, it took 30 years for us to become such, especially in New Jersey, a mediation-centric country and state. We now have all of our cases. Before you will get a trial date, you will be obligated to attempt mediation. There are many states in the US that are starting to do this. New York is finally starting to have it, but there's still an opt-out provision, which means it's not necessarily as mandatory. So it's taken many, many years to change the mindset. So we promote it. We think it's really an excellent method. But again, you will get resistance. There's the political we're talked about in the EU. And there's also attorneys and judges. They're afraid of losing control. They're afraid of losing revenue. So mediation does take time. Once people do it, and once people have tried it, it has been extremely successful, and it has decreased backlogs in courts, it's speeded it up, it's preserved relationships, and all the benefits that anyone who's watching, who's involved with IMA knows the benefits of mediation. Thank you, David.
Thanks, Jennifer. Let me add two comments to this, because the first one is a trailing comment from our Singapore Convention discussion. I've sent to Laura Kaster something I think those that are very interested in is a seminal textbook. It's a special additional journal from Cardozo that was worked on and has been published. Laura will send it out if she deems it appropriate through IMI to anyone that would like to find out about the link and how to access that particular book. And it really is a amalgamate of what was thinking, or what the thinking was in order to create the convention. As far as this issue, which is really the dominating force, it's one of the factors of what the New Jersey City University's IDR, when the mission and objectives of creating this was by me. It's all about business. And if we focus on the word business, it's not necessarily about the lawyers. It's not necessarily about the providers. We are a tool to assist in the process. But the business side is getting in touch and not just convincing, but really educating first. Your chambers of commerce, your consulates, your departments of foreign ministries that focus on foreign direct investment. This is the key element that has been missing. And I wouldn't say it's that we did anything wrong, because if you go back to my comment on the last discussion question, mediation is still a growing experience. I mean, I remember when I was in law school in the late 1990s, ADR was not something that was predominantly well known. I mean, there were a few courses out there. Today, ADR is, the bee's knees for most law school students. And that's a good thing. But it's a growing process. And I think you can look at mediation not only as part of the ADR process, but more importantly, I advocate that mediation is its now own discipline, and it's grown up. And in that grow up phase, we'll call it, maybe it's in its young 20s now. And it has still a lot of work to do. And part of that work is educating governments, chambers, business communities, and those that really, once they understand the value added, and that's the key here. If they only look at this as a byproduct of conflict, then they will always default back to their counsel and only look at this as a cost of doing business. But if they look at this as a value-added process and proposition, and once you sit down and have a conversation, which I've had with many ministers of foreign affairs and around the world, and those that are in economic attaches, and you spend a couple minutes with them, or heads of chambers of commerce representing countries around the world, in your backyard for those around the world that are in many different countries. Within a few minutes after you explain what mediation really is and the benefit to mediation to allow their small and medium-sized companies to take that dip into the big end of the swimming pool, they then say, this is a tool we can use to promote and advance business. It's not just a tool to worry about when the conflict arises. And that goes back to Bob Margulies' comment about culture. So there's work still to be done.
David, I think what's important, people may not realize this, but your IDR is part of the business school in your university. I think one of the places that we're missing out on is not having business schools teach. We know that lawyers, when we teach lawyers in law school, some of us have done, we know that like they're kids to me, the kids get all excited and they don't want to be trial lawyers because they recognize there are no trials anymore, but they do want to participate in ADR. And I think the same thing is so. The other thing that I think we forgot to mention, New Jersey is, and I'm looking at the Hudson River from my window, New Jersey is across the river from the commercial capital of the world. So why New Jersey and not New York? Well, there are a number of reasons, but New York doesn't have, and we don't expect it will have, anything like legislation that would promote cross-border enforcement. And so we invite you to take a look at GMXC mediation. We think you're going to like it.
Could I just add one more thing about that? New Jersey also is where the ports are. The ports of New York, so-called New York, come into New Jersey. New Jersey has many, many multinational companies here. Many fled New York and moved to New Jersey across the river for many reasons, after 9/11, of course. Certainly it's more cost effective. And we have a very strong mediation culture in New Jersey. For many years, we were one of the first states to implement, to try as a pilot program and then implement this mandatory mediation system.
And I just want to add one, before I go on to the next question, one thing to that. There is going to be a period of time when we're all going to be doing things online. There is just no doubt about it. The courts are closed in many states and are just bringing out some video solutions piece by piece. Dispute resolution needs a solution right now, and we can do that online, not just in person and conveniently close to New York, but online. I just point that out to you. I have another very interesting question, which is, does the ARB-Med-ARB process that the New Jersey statute has enacted run opposite to the mechanism contemplated under the Singapore Convention? And yes, it is not the same. It is not, I don't know that opposite is the right word, but it's quite distinct. The idea in the Singapore Convention is a mediation that results in a settlement agreement that could then be enforceable. It doesn't, in fact, it doesn't permit it to start with litigation, where we do permit it. You have to take it out of litigation and bring it into arbitration, but it could have started as a litigation. It doesn't permit you to start, the Singapore Convention does not permit you to start in arbitration. So this is a very different animal. And it is a solution that was matched with not the Singapore Convention, but the New York Convention, which is enacted in over 160 countries and where you can get your judgment enforced in over 160 countries. Does anyone else want to comment on that?
No, I think that is absolutely correct. And I think the way that you've illustrated the apples and the oranges, and we're not trying to assuage anyone, because a number of us, including Laura and I, are very big proponents of the Singapore Convention. I was a part of the only actual academic study during the convention. There were other, though, academics like Stacy Strong from the University of Missouri Law School, who really got the ball rolling for the Singapore Convention, and Debbie Masucci and IMI, who really anchored this through the Global Pound Conference series and did their surveys, and Queen Mary Law School, who had done surveys as well. So for the audience, we want to be clear that we are very supportive of this, but there needs to be other tools in the toolbox. I think, first of all, even if you put aside some of the comments that we've made about the obstacles still and challenges ahead of us for the convention to become a full, living, breathing tool that is synonymous with the New York Convention's arbitrable award process. Even when that happens, the New Jersey framework is not competition. What it's doing is it's giving optionality, so that if and when you're sitting down with your counsel and you're looking at ways that are the best available pathways for you and your counterparties to resolve your issues, you have some selection processes to consider. And I think that's important to convey that message as well.
Thank you, Dave. And I think we have one more question. I believe it's just one more question, which is family estate disputes. Can you confirm that the new New Jersey law and GMXC covers that? And actually, it doesn't quite, in that if it's an actual property devolution under an estate plan, it would not be covered by the GMXC, the New Jersey statute. If it's a business ownership dispute or a shareholder or partnership dispute, it would be covered. So it depends on how it arises, I think, but estate matters themselves are excluded. Is that right, David?
That is correct. Yeah, I think to keep it somewhat simplified, and we discussed a little bit before with this, the family business aspect. Think of it this way: any family business operation that then has a family business dispute amongst brothers, sisters, fathers, whatever, inside the business operation, and then any of its assets that it owns, would certainly be something that is applicable under the statute. But if you are in a court, for example, in New Jersey or in the United States, or in our state, it would be in our chancery courts, that are really dealing with family matters that are outside of the business, but include business assets, then I think there is an area where we have to be careful not to suggest that this law should be used. But and by the way, that's the same thing with the Singapore Convention, as well as the New York Convention for Arbitral Awards. If you have a divorce between a husband and wife or other partners in today's world, this is not models that will be applicable.
Okay, I do have a few more, so I will try and answer a couple more. What are someone wanted to know about researching where we could go to research these issues. I'm going to give that to David after a moment, but and what measures do you think countries need to take before ratifying the Singapore Convention? I think that's a political question within each country, so I'm not going to be able to, I don't think, be able to give that as an answer. I do think that the cultural change that Bob mentioned is also important, but I think enforceability for international disputes, it was the key underlying missing link. So David, could you tell people where they can go to research the best solutions in various countries?
Yeah, so there are a number of different resources out there. I mean, the IDR is constantly engaged, for example, as one example, and that's not just to promote my particular institute, because frankly, there are many institutes like mine around the world that are doing good work within the commercial sector to promote mediation in many countries. So think of them as depositories for access to academic scholarly work, as well as active participation with their chambers, with their governments to utilize arbitration or mediation, in this context, mediation. In addition to that, for purposes of IMI is a worldwide platform that is also very actively engaged in promoting mediation culture and training at the highest levels of standards. So that's another example of where stakeholders can go to learn more and to understand. And then there are many universities on the general level, not even institutes, but that are leading in this charge, if you will, alongside NGOs that, for example, Jennifer is affiliated with, that do good work all over the world, trying to assist nation states and their government actors on understanding the benefits of mediation and why it should be applied within their legal systems. The question on the political question of ratification is a two-pronged approach. And to be fair to nation states, as I said before, the United States was on the forefront of this. Really, California, I believe, was really on the forefront of this first. So it took time, and even in our own, in the United States, there are still many folks in many sectors, that, including the business sector, that don't really understand it. They still think mediation, lack of a better word, is meditation, or they think mediation, even in official capacities, is synonymous with arbitration, and they're two different processes. So be patient. The key is to allow nations to understand mediation and understand its benefits and how it correlates to their economic growth, how it helps save both inside their taxpayer systems, but most importantly, how it can promote and advance companies in this globalized environment.
I just want to make a comment, if I may. I just have two comments. One is that the way it is political, but also if there are organizations within each country, for example, the American Bar Association, JAMS, which is a large mediation provider. There are a lot of organizations that have been asked to weigh in to give their influence as to whether or not the country should ratify such a, the Singapore Convention, number one. So I think it is political, certainly, it's business, it's lawyers, but I think people can weigh in and promote, have these organizations to say, we promote it, we support it, we recommend ratification, number one. Number two, I agree completely with you, David, about IMI, and at our GMXC panel, everyone must be IMI certified if it hasn't already been said. So I want to stress that we believe the importance of it.
Thank you, Jennifer. Thank you, David. I have one final question, and I think it's an important one and a great one to end on. It is the cost. Is this going to be more costly to do a hybrid process? And quite the opposite. This is the opportunity to resolve your dispute. One of the complaints about international arbitration, which has been the go-to solution because of the New York Convention, one of the key complaints is that it's increased over time in cost and complexity. And mediation provides the opportunity, not necessarily the absolute result, but the opportunity to resolve a complicated dispute in a much more abbreviated process and getting the same ultimate award, the consent award at the end. So it's and the global pound slide that we had at the very beginning that clearly indicates that the users, the corporate users, very much understand this and really want a hybrid solution. They want a solution. They don't care what the process is called. They want a solution. This is the most efficient and least costly way to resolve disputes internationally.
And if
so
Excuse me, Laura, I like
coming to the end, Laura.
One quick thing here, just to be fair, since it was mentioned JAMS, AAA is also a very active player, and both JAMS and AAA and the ICDR, International Arm of AAA, have been long-standing supporters of promoting mediation throughout the world. They're also very active members of IMI. And like NJCU,
CPR as well.
Yeah, and CPR as well. And
the ICC.
I think the ICC has been very active as well. So we just want to be fair here that all of these great organizations are recognized for their philanthropic work and activism in promoting all of our initiatives. Laura Skillman will send you out what's called the QAP process to become an IMI certified mediator. And NJCU is actually a QAP provider as well. And so are all these organizations. So again, we just to be full disclosure, I think it's important to recognize their good work as well. Laura?
I'd like to say one other thing about arbitration and why we feel mediation and the Singapore Convention. And again, we all believe in the Singapore Convention. We are big supporters of it. We just know it will take time, and we have a method a little bit sooner and earlier that's available now. But with respect to arbitration, I agree with everything Laura said about it. And it is basically a private legal system with an extremely limited right of appeal. It's very time consuming and is much more expensive than mediation. I was just at a conference, and one of the things we were talking about expedited arbitration. The average time for an expedited arbitration is 6 months. The average time for a regular arbitration from start to finish is 2 years. To me, that is not fast. Mediation certainly will trump that. I'm sorry to use that word. Will actually is the way to go if you want a faster, cheaper method.
Laura?
I just want to thank you all and turn it over to Laura Skillin, who's so wonderful in helping us get this online.
Yes, no, thank you so much to all of you for your fantastic comments and insight. I think it's been very helpful for me personally, and I'm sure very helpful for the attendees. Thank you as well for the attendees for your fantastic questions, and I will send out the materials to you in probably the next 20 minutes. Additionally, there was a question asked about whether materials will be made available, and yes, the video from today's webinar will be on the IMI website in the next couple of hours, so check us out at imimediation.org. And thank you again to all of you.
Thank you, Laura.
Laura.
Thank you.
Thank you.
Thank you, everyone.
Yeah.
Bye.